Good morning, friends. Now this is in continuation to my earlier video itself only, which was on house tax. Now here we will discuss how the taxation structure has to be made. Now generally we are categorized in cantonments as there are three kinds of properties. Now we'll talk of the first type of property, which is called the main estate, which is a building which is either or and is in self-occupation. This nature is generally governed by the parliament, and an adjudication on this has not to be delegated to the federal legislature. Now it's very important, what I am talking today is covered under an act called the House Accommodation Act. Therefore, any breach of the direction or change of purpose cannot be inflicted by the authorities without seeking a fresh sanction from the parliament. Now, House Accommodation Act legislation does not provide for owners of such properties to redress them from federal courts. So House Accommodation Act bungalows cannot go to the local courts. Now, what is the second property within this? This is called a tenement on private lease. And this lease is under the House Accommodation Act 1902. Let's say there is a particular amount of rent, say 10,000 rupees per annum, which I make under my tenancy for a period of financial year 22 or whatever, 23. This is called the assessment year. Now this will be charged flatly 9%. But here there is a mistake. What is the mistake? That the department or the tax superintendent does not, he does not redeem my maintenance expenses, my living index expenses. So what he has to do is, he has to deduct my building maintenance expenses, which runs in 2,000 these days. Similarly, because of that material cost, as well as my cost of living index. Now, since I am staying in the bungalow by myself and this rental is only my income, so he'll deduct both these things, and then the amount which is my income will be taxed as 9%. But what is happening? I'm being taxed flat 9% on the rental income as per the lease done. So is this right? This is not right. But we people are so ignorant, we have never ever challenged all this. So we need to wake ourselves, And the third property is that it is not on a lease or a documented program system, but it is on a tenemency. Let's say a portion of the bungalow is rented to a private or an individual, and this is only if under the House Accommodation Act, if for once my property has been de-requisitioned by the government or by the Ministry of Defense at that time or the British. Because then only my property is subjected to private tenancy. Otherwise, there has been a restriction under the House Accommodation Act that I cannot rent my property over and above to the government itself. Where is it written? For Ambala Cantt, it is written in the bylaws books, which is on page 196 to 200 if we read it. And the similar bylaws under the House Accommodation Act or otherwise in 1930 or 23 must have been made for your cantonments also. So please dig into these bylaws. So once this survey, this bylaw is there, so every predecessor must know whether his bungalow has been de-requisitioned. It must have been on hire by the government or by the British. Now just see to that. Now friends, in continuation this time, when the tax superintendent will be visiting your bungalow or your estate or your property in the civil area till it does not get excised for the triennial assessment, please make sure what you are going to ask and what you are going to do with this team which visits you on a physical inspection of your estate and property. So let this report on a physical inspection be made by this team, provided you are also physically present with them or your representative is standing. Once this report or this assessment is made, it is to be given to the owner, and the owner has to sign on this report. Now let's say the tax superintendent or his team makes a report which is not preferably acceptable to the owner or his representative. He will make sure that he writes a dissent note there itself on the report. Presumably, tax superintendent or his team will not let you do that either. Make sure that very moment you sign a dissent under a letter and get it received by the tax superintendent or the CO of your cantonment in his office, taking acknowledgement for yourself, because this is very important. Once this objection is there, once you are called for raising objection on your tax structure or your tax assessment being raised, this letter will help you. So this letter becomes a proof. So friends, please remember this tax structure, which I have already explained in my earlier video, is under the Cantt Manual 1909. I'll quickly read that again. Taxation on property of which government is owner or occupied, as taxes levied in a cantonment are practically levied for the benefit of the cantonment, which has to provide for any deficit there may be in the cantonment fund. No tax payable by government should be levied. If the tax imposed on a building and land is payable by the owner, such building etc. ought not be exempted unless they are the property of the government. If the occupier, they should be exempted only when government is the occupier. Now, if we read Rule 2 for the taxation structure under the Quartermaster Journal 9 Circular of 1894, when an officer occupies quarters the property of government, if either by terms and so or by an agreement, he shall be payable to the tax. But if it is a tax payable by the owner, the government as owner is exempted. See, now remember, he says if it is a government property and an agreement between an officer and the government is there, and in that agreement there is nowhere written, it is written that it will be the owner who will pay the tax. Now, who is the owner? Here in this property where an officer is, it's the government. So now here the government will be exempted, he says. Now, there was a clause in 1880 till 1924 that buildings which have not been occupied or productive of rent shall be exempted from paying taxes, under which section, subsection 1 and clause A of the Cantonment Act 1889. But this gradually got removed. Now, let's read Rule 9, Quartermaster Journal Circular 24, 1894. Where any tax imposed under section 17 subsection 1A of the Cantonment Act, person owning or occupying building, holding or lands within a cantonment, according to their circumstances, as written on page 54 of Appendix 7, is liable to pay. Now here is that word called occupier. Where is it defined? Read section 2 of the Cantonment Act 2006. Now, there is a Government Army notification number 56 of 20th January 1911 on the Gazette, page 1, dated 21st January 19. Every cantonment in British India, Government of India, in which a tax on building is for time being imposed under section 15 subsection 1A of the Cantonment Act 1910, the following classes of buildings shall be exempted from such tax. Which are these buildings? These are those buildings which are occupied as an hospital, a school, a charitable institution, or a religious place. So that means within the cantonments we were allowed to do all these things, and on these old grand bungalows. So friends, I think I am trying to bring you at that page. In my next video, I will be explaining how and what kind of a letter should people write when they are not even mutated in the GLR, or they have purchased the bungalow illegally, what the department says, and have not been subjected to house tax. Good day. Thank you.